This is Dr. J. Kent Gregory. Welcome to part two of chapter three, the chapter on litigation. So let's proceed to the types of juries. So first, there are grand juries. These are bodies of citizens examining whether someone accused of a crime should be formally charged. And these are in criminal proceedings. Um, they serve as a procedural step to prevent prosecutors from abusing their powers of arrest and indictment. They meet for an extended period of time, and they hear several different cases in one day, and they do not determine guilt or innocent. So they are just determining whether someone should be formally charged. And then there are petty juries. Uh, from the French petit. These are bodies of citizens determining guilt or innocence in a criminal trial or liability in a civil trial. So they're impaneled, meaning they're put on uh, the case for one trial. They have to arrive at a unanimous verdict, and they determine guilt or innocence. Uh, Requirements to demonstrate a standing. The party should prove that it has an actual case to proceed. The case should be brought by the right person at the right time. So a ripe case is a claim that's, or a ripe claim rather, is a claim that's ready for litigation. Moot, a case is moot if granting the remedy asked would not help the plaintiff at all. So, and then the ability to prove standing does not imply that the case has been won. So this is just a procedural bar that one has to clear before the case proceeds to litigation. So procedure for pretrial. A dispute can proceed to pretrial stage when A, issues related to the subject matter, jurisdiction, standing, and personal jurisdiction are sorted out, and B, parties have hired counsel to represent them. And then litigation begins with the filing of a complaint by the plaintiff. And the complaint is just the initial document that starts the lawsuit. So a complaint will end with what's called a prayer for relief. And this is a claim by the plaintiff for damages sought from the defendant. The plaintiff may seek damages, specific performance, or a temporary or permanent injunction. So three things: seek damages, specific performance, or whatever. So damages, this is a loss suffered by a plaintiff, and it's typically expressed in terms of money. Specific performance is a non-monetary remedy available in certain cases where the defendant is ordered to perform the specific act agreed to in a contract. And then an injunction is an order by a court to a party to do something or to stop doing something. So more about the procedure for pretrial. Complaint is filed with the clerk of court. Summons are issued to defendant along with a copy of the complaint by the clerk. And then the summons is sent to process server to effect service on defendant. More about the procedure for pretrial. Once the defendant has been served, a timely response to the complaint is important. So failure to reply can lead to the plaintiff to ask the court to issue a default judgment against the defendant, meaning the judgment is entered against the party for misconduct or failure to answer. Cases involving multiple plaintiffs, for example, class action suits. There are lead plaintiffs, and these are the representative plaintiffs of the class. And to talk about class actions, this describes a lawsuit in which a representative plaintiff represents an entire class of similarly situated plaintiffs against the defendant. And answer to complaint, which will wrap up part two of chapter three, the defendant must file an answer to the complaint within 30 days, and the answer contains an affirmative defense that the defendant wishes to pursue. And so you're asking, well, what is an affirmative defense? Because this is a defense that does not deny the defendant's actions, but provides a reason or justification, such as self-defense. And pleadings, the complaint, answer, and any supporting documentation. So that brings us to an end of part two of chapter three, and we'll pick up with part three after after this.